Hello, my name is Len Foy, and I am a real estate attorney located in Nashua, New Hampshire. The name of my office is Foy Law Office PLLC, and I'm here to discuss important features of the modern practice of buying and selling real estate. This is the next installment of an ongoing series that I've been producing, and the subject of today's discussion will be deeds and their importance and relevance to real estate transactions. You know, real estate can be such a mysterious process. Most people only buy or sell real estate maybe 1, 2, 3, 4 times throughout the course of their lives. And so it raises the question, it begs the question really, how can somebody truly understand something that they only do a couple of times in their life, especially something as complicated and as complex as buying and selling real estate? Deeds are legal documents, and I should say, before I delve into this any further, it's early in the morning and I haven't had my coffee yet, so forgive me. I should set this up for our audience. Again, my name is Len Foy, and I'm a real estate attorney in Nashua, New Hampshire. The name of my office is Foy Law Office PLLC, and we handle commercial and residential real estate transactions in 4 New England states. There, we got that out of the way. Part of what we do, what I do as a real estate attorney, is we handle real estate closings, transactions. On the West Coast, they call them escrows. And as a part and parcel of that process, we prepare legal documents. That's a big part of the practice of the modern day real estate attorney, and something that we don't hear a lot about. We prepare legal documents. We prepare deeds. We prepare mortgages, which are referred to as deeds of trust, again on the West Coast. We prepare assignments and discharges and releases. We prepare a whole host of different legal documents, and it's actually a big part of what we do. And it's an important part of what we do, because I can tell you that some percentage of the overall problems that we run into as real estate attorneys are related to defectively prepared documents. Documents with errors, documents with mistakes of identity, wrong property, wrong people. I've seen it all, wrong county. So it's sort of an unheralded virtue of the modern real estate attorney when that attorney is capable not only of handling closings and doing everything that goes into that process, but also carefully reviewing and preparing legal documents in connection with the real estate transactions that they handle. There's the big setup. Now to get to the meat, to the heart of the matter, if you will. Deeds. It's a term, if you buy real estate, you might hear that term 10 times, you might hear it 100 times. I still think that some percentage of people exit the real estate buying or selling process not being entirely clear as to what a deed is. And so I'm hoping that in the course of this lecture this morning, we can concisely, succinctly, and definitively identify what is a deed, what does it do, and should you contact my office. There's 2 circumstances under which people might have a deed prepared. First of all, let's back up. What's a deed? A deed is a legal document that conveys ownership of real estate from one person or party or entity, company, to another. So using the ultra simplistic example of myself selling you a piece of property, amongst other things, that transaction ultimately would come down to a written document in which I would be agreeing to sell you a piece of property that would be described, which we'll get into, and then signed by me, and then my signature would be notarized, which means there's some definitive proof that in fact I signed it. Now, this is a lecture that could go on for days, because there's really so much to say when it comes to deeds. We're going to keep it very simple today. We're just going to talk about your basic deed, what's in it, what should be in it, and whether you should contact my office to assist you. First of all, again, the most basic features of a deed is that we have a buyer, we have a seller, and we have the property identified, We sometimes have the price of the property. We have some signatures and some protocol in terms of how these documents get signed, and we typically have, well, we virtually always have notarization. So, but buyer and seller can be misleading terms. Some might use the terms grantor, grantee, transferor, that's the person transferring the property, transferee, that's the person the property is being transferred to. Why would we opt to use grantor and grantee rather than seller and buyer? Well, because properties are not always bought and sold. Sometimes they're given gratuitously, as in the case between family members, or they're conveyed into a trust for when no money is actually changing hands. But for the purposes of this lecture, we'll just use these terms interchangeably so as though not to confuse the matter. But there may be circumstances where people want to convey a piece of property that they own to a child, or to a loved one, or to a family member, or to a friend under some circumstances, or to a charitable organization. And obviously, under those circumstances, we would still use a deed, even though no money is changing hands. So the most important feature of any deed is who are the parties involved, who owns the property, and therefore who is transferring the property, and to whom is it being transferred. We'll spend a little bit of time on jargon. These deeds are typically entitled deed. So at the very top of the document, it's not uncommon to see the word deed. You may also see the words warranty deed. You may see the words quitclaim deed. You may see the words fiduciary deed. Without belaboring the subject, different deeds are utilized under different circumstances. Typically, in New Hampshire, we use warranty deeds. In the Commonwealth of Massachusetts, we typically use quitclaim deeds. Warranty deeds are typically used when people are actually buying a property for money. Quitclaim deeds are more often used when, say, one spouse is putting another spouse on the title of their property, or two spouses are maybe conveying a property into their trust. So a warranty deed is more commonly utilized under circumstances where property is actually being purchased. A quitclaim deed where property is being transferred, but not typically in return for any money or what's known as consideration. Again, the standing rule, the rule of thumb throughout this series and virtually any video that I do is if you have any questions, please contact my office. My phone number is 603-598-4030. I'm on the World Wide Web at www.foylawoffice.com. My email appears on our website. I'm a great communicator. I love answering questions. Consultations are virtually always at no charge. If there's ever any intention to charge anyone, that intention is disclosed up front, but it's rarely the case. I think I'd only charge if somebody needed me to do a lot of work in connection with a consultation. But the rule of thumb is that consultations are free. And so you'll have an ample opportunity, whether on the telephone or via an email, to find out more about my services. Okay, the next thing that we need to be clear about when it comes to a deed is there money changing hands? And if so, how does it affect the deed? Well, again, we conduct real estate transactions in 4 New England states: New Hampshire, Massachusetts, Rhode Island, and Maine. I'm going to deal with New Hampshire and Massachusetts today, although Maine and Rhode Island are not terribly dissimilar. In New Hampshire, we don't actually put the price of the property in the deed. In Massachusetts, we do. Either way, someone might say, well, what's the relevance of that? Or what difference does that make? Well, the difference that it makes is that if you record a deed and money is being paid or money is changing hands for the property, there are typically what's known as transfer taxes or tax stamps that need to be paid at the time the document is recorded. And those tax stamps or transfer taxes or revenue stamps, they're called 100 different things, are driven by the sales price. So even if the sales price is not actually written out and identified on the deed, it needs to be disclosed at the time of recording because the transfer taxes are typically some multiple or some function of the sales price. What's another important feature of the deed? We need to describe the property conveyed. And this is probably the single greatest reason why I would implore people not to attempt to prepare their own deeds. Certainly it's your right, and I don't doubt for one moment that there are people who are bright enough to do it on their own without the services of an attorney. but one of the most frequently committed mistakes or errors that I run into in my practice is deeds that identify the wrong property, which means you're conveying you intend to convey one property, but you in fact convey a different property with all of the attendant hassles that could go into that sort of thing. You can only imagine. Or we're all clear on the property being conveyed, but we haven't done it right. We didn't describe it right. And I guess when I say describe it right, you will know if you were to get on the internet, if you were to look at a deed or look at your deed or look at a friend's deed, you would know that in a deed we don't convey 254 Main Street, 5 Washington Street. We don't convey, sometimes the property address or the mailing address is identified in the deed, but typically we go with what is called a legal description. And a legal description can be anything from meets and bounds, which is somebody actually pacing off the boundary lines of a piece of property so that it's 100 feet in this direction by 200 feet in that direction. Very specific, delineated legal descriptions. Or it could be reference to a lot number on a tax map or on a subdivision plan. And again, the possibilities are endless there, but you certainly don't want to identify the wrong plan or the wrong lot. You don't want to leave out an easement or a right-of-way. So the legal description, the thing about a deed is that everything in a deed is critically important. We've got to have the right grantor. We've got to have the right grantee. We've got to make sure the price is accurate, so the transfer taxes are accurate. And yes, we've got to make sure that the property is properly identified. Once we have identified our grantor, our grantee, we know what kind of deed it is. The title is at the top of the document. We've got to get into the legal description. We nailed that. Now we have to get into execution. And execution is just a 50-cent word for signing. This document needs to be properly signed, which means it needs to be signed by all of the grantors. The grantee or transferee rarely signs a deed unless, what I see frequently is in a condominium situation where they are asking that the grantee or the transferee or the buyer specifically accept the rules and regulations or bylaws of the condominium association. So to avoid a situation down the road where somebody who buys into a condo association says, hey, I didn't know about this, I didn't know about that, we have them sign something right in the body of the deed that they are knowledgeable and understanding of the bylaws and that they agree to them, signed Mr. or Mrs. Buyer. So, execution. The document needs to be properly executed, which means, under most circumstances, all of the grantors need to sign it. If a grantor can't sign it, and it has to be signed by their power of attorney, that can be done, but it's a special case. Call my office for questions. You should not assume in every case that a deed signed under power of attorney will be acceptable. Oftentimes, it is not acceptable. Notarization. We need a proper notarization. We can't have people walking around with deeds with signatures on them that are not notarized. A notarization is a check and a balance that the person who is alleged to have signed that document did in fact sign that document. Because if we ever had a deed which had been fraudulently executed, or which had not in fact been executed by the person that we're all saying executed it, we could have huge problems. It is as terrible a situation as somebody literally being swindled out of their home. And that's what could happen if we didn't insist that all signatures on a deed be notarized. Let's talk about format. It has to be in the proper spacing. It has to be in the proper format. It needs to observe set margins, which are different not only in every state, but sometimes they're different from one registry to the next. So don't overlook the importance of making sure that your deed has been properly formatted. The print can't be too small. The print typically can't be too large. You should use black or blue ink. Don't use red. Whiting out pieces of information on a deed is generally prohibited. Better to cross it out and have people initial those changes. If you try to white things out on a deed, your deed will typically be rejected when it goes to be recorded. Original deeds only. You cannot record copies. Again, I'm not speaking universally, I don't know the specific rules and regulations of every jurisdiction in the United States. I practice law. I'm admitted to practice in New Hampshire, Massachusetts, and Maine. We conduct real estate transactions in Rhode Island, but I'm not admitted as an attorney there. And I'm licensed as an attorney in the state of California in active status. So I'm not talking generally about selling real estate in Illinois or Alaska or Guam or the Virgin Islands. I'm only speaking to those jurisdictions where I'm admitted to practice law and active. But I think it's probably almost a universal rule that photocopies cannot be recorded. So the Registry of Deeds will insist upon an original document. If you go to the registry with a photocopy, that document will likely not be accepted for recording. And then finally, there are fees. There are always fees to record legal documents. They vary from jurisdiction to jurisdiction. There's so much more that I could say, and I'll probably end up doing a Deeds Part 2 or a Deeds Part 3. Who knows how far we'll go with that? Because it is an important part of every real estate transaction, and it's a subject matter that is rich with examples of things that went well, things that went wrong, how to avoid trouble, how to avoid falling through trap doors, all the traps for the unwary, if you will. Now let's talk about how I might be able to help you with a deed. There are many circumstances under which you may need to prepare a deed. You may want to put a spouse onto the title of your property. Maybe this is a property that you bought many years ago, you've recently gotten married or perhaps remarried, and you'd like to add your spouse to the title. You're going to need a deed. You may want to put the property into a trust that you just created. You're going to need a deed. You may be selling your property. You're going to need a deed. So anytime you are looking to either convey your property outright or to change or alter the ownership structure of your property, a deed is what you will need to do. One of the things that my office does, whether we're handling a real estate transaction or not, is we prepare deeds, we record deeds, we review deeds, and we work with people to prepare deeds and review them and record them. So anything from A to Z in connection with deeds involved in real estate transactions, we handle that. Feel free to call my office for a free consultation. Deeds are relatively inexpensive. I'm reluctant to quote fees because I don't want to mislead people. Every project is different. But if you are being quoted what you would consider to be a large amount of money to have a deed prepared, keep shopping. Because preparing deeds is a relatively straightforward matter and a relatively inexpensive matter. And I would counsel people in the strongest terms possible. Do not attempt to prepare your own deed. You probably will make a mistake of some kind, with all due respect. I don't doubt the ability of people to pull it off. But even if you make the tiniest mistake, guess what? It'll have to be redone. And you'll have to pay an attorney to redo it anyway. So rather than spending a lot of time trying to do it, make a mistake, and then have to pay somebody else to do it, pay the somebody else to do it right away. Again, there's so much more to say, and we probably will do future installments. Deeds are such an important part of the fabric of our real estate marketplace. They need to be done well, they need to be done right, and they should be done by an attorney. My name is Len Foy, and I'm a real estate attorney in Nashua, New Hampshire. I hope to be your real estate attorney. If you are considering preparing a deed or having a deed prepared on your behalf, I hope that you'll call my office. It's an important part of our portfolio of services and something that I'd like to personally assist you with. Have a wonderful day, and for more information, please call my phone number, 603-598-4030, or look me up on the World Wide Web at www.foylawoffice.com. Have a wonderful day, and I hope to hear from you soon. Bye-bye.